Hi, and welcome to this edition of the People's Law School webinar series. My name is Keith Taylor, and today we're going to talk about things that you want to consider in filing a small claims lawsuit. Understand that in filing a small claims lawsuit, your amount that you're seeking cannot be more than $5,000. Also understand that the information we're providing today is relevant to cases in the state of Florida. So when you're thinking about filing your own small claims lawsuit, there's some things you need to analyze that you need to think about before you decide to do that. You're going to want to think about the costs, the time, and whether you can collect the eventual judgment that you're seeking. So let's talk about those for a minute. Costs. The costs involved in a lawsuit, even if you do not have a lawyer, can be quite expensive, especially when we're talking about a claim that is less than $5,000. For example, at the time of this seminar, the filing fee on a small claims lawsuit is $300. That's the money that will have to be paid to the clerk of court, whether you have a lawyer or not, and whether you're seeking $30 or $3,000, the filing fee is still $300. In addition to the filing fee, there are service of process fees. Those can be sent by certified mail. We talk more about this in another webinar that we do as far as the procedures. But in thinking about the costs, it's very likely that you'll have service of process fees of about $30 in the case. Then you also have to consider whether there will be discovery involved in your case. If there's discovery, those can really add to the costs of your case. Things like depositions and photocopies. Also, you're going to want to consider collection. If you obtain a judgment, are there going to be costs associated with actually collecting the money that that judgment represents? So it's not uncommon in a case, even a case involving small claims, that the cost that you will incur would be up to maybe even more than $1,000. Now sometimes you can recover those costs at the end if you win the case, but it's something that you do want to consider before deciding whether to file a lawsuit. Next, you're going to want to consider the time that's going to be required of you in this case. You're going to have to take your own time to draft the documents necessary to file the lawsuit. And there are forms available, but it's still going to require your time to do that. You're going to have to take your time to carry that papers down to the clerk of court for actually filing your lawsuit. You're going to take time involved in the discovery process, trying to get information, trying to get witnesses. You're going to have to take your time to attend a pretrial conference, which is sometimes also a mediation. That could be several hours of your time just in that hearing alone. And of course, your time if you have a trial in the case. Again, another couple of hours likely that you'll spend down at the courthouse trying to collect the money you think you're due. And lastly, you're going to want to consider the fact that if you win your case, you're going to get a judgment that says you're entitled to the money, but you may not necessarily get the money. So you're going to then spend additional time in trying to collect that judgment. You could spend upwards of 10, 20, 30 hours of your time in handling your own small claims lawsuit. Important to understand, though, is that your time spent in the lawsuit usually is not something that you can collect as part of your claim. So if you have to miss time from work to attend a hearing, you cannot include your time missed as part of your claim, which is the basis of your lawsuit. So you're really going to want to look closely at how much time is it going to take from you and what's that going to eventually cost you before you decide whether to file your own small claims lawsuit. And you're also going to want to consider collection. I've mentioned it a couple times. Just because you're right and you're able to prove you're right in a court, what you will get is a judgment. A judgment is a piece of paper that says you are right and you're owed money by the defendant, the person on the other side. That doesn't necessarily mean that that person will pay you the money. You will get a document called a judgment that says you're entitled to the money, but then it becomes your job to actually collect that money. In fact, some people are what they call judgment proof. That is, you can't actually collect the money. What if the other side, you win and they file bankruptcy? These are things that you're going to want to consider. Can you get the money if you win? So you want to think about all these things prior to making that decision that you want to file your own small claims lawsuit. Now, there are some other considerations that you need to think about as you analyze this decision. One being the statute of limitations. Now there's laws that say that certain cases have to be brought within certain times. And so if it's been a couple of years since the problem arose that you are wanting to file a lawsuit on, you better look carefully and make sure that your claim isn't in fact barred by the statute of limitations. You could go through all of that time and all of those costs and have the judge throw your case out, leaving you not to recover any of your money nor any of the costs that you've invested in your case. You're also going to want to consider your ability to prove your case. Do you need witnesses? Do you need photographs? Do you need documents? You may have somebody who heard something. Is that person available to come into court and testify? So you want to consider, what is it going to take, and do you have the ability to show the judge that you're entitled to win your case? You're also going to need to consider this thing that we lawyers call jurisdiction. Can you sue the other side where you want to sue them, in the county where you live? Now, there's laws on that, and usually you're going to be stuck pursuing that person in the county where they live, which may be a different place, maybe even a different state. So you're going to want to consider the jurisdiction over the defendant, over the other side. And of course, we talked about at the very beginning, jurisdiction of the court. Remember, a small claims case is limited to cases where the amount you're seeking is up to $5,000. If you're seeking an amount in excess of $5,000, there are other courts and other ways to go about doing that. So you don't want to seek recovery of $10,000 in a small claims case because there's not jurisdiction in the small claims court to do that. Also want to consider, maybe your case involves a contract and the other side didn't live up to their obligations under the contract. You may be entitled to recover attorney fees under your contract, in which case, even though it may be a small dollar figure that you're seeking, it may justify hiring an attorney if you can recover attorney fees in your case. So you'll want to look at that. And most importantly, you're going to want to look at the rules that apply to this case. Small claims cases are governed by a special set of rules of procedure called the Small Claims Rules of Procedure. But what you'll see if you look at those rules is that there are other rules that also apply. The civil procedure rules apply also, and they can be quite complicated. All of these rules do apply even though it is an informal setting of the small claims court, where most people do not have attorneys. And most importantly, in considering the rules, is to consider that the evidence code, the rules regarding what evidence can be considered by the judge, applies. The judges oftentimes will relax the rules of procedure in these cases, recognizing that the people involved do not have lawyers and do not have special legal training, but the judge is not permitted to relax the rules of evidence. So if you're bringing the case and you are then the plaintiff in the case, you have the burden to establish your entitlement. You have to prove your case, and you are stuck doing that within the rules of the evidence code. In Florida, that can be found in Florida Statute Chapter 90. It's a little complicated to understand, but the most common one people are familiar with is the hearsay rule. You'll need to pay attention to that. But if you decide that you want to file your own lawsuit after making these very thorough considerations, I suggest you consider our next seminar, which is going to be on how to handle your own small claims case. Thank you for attending. My name is Keith Taylor.